Welcome to this Evershed Sutherland PROPcast. I'm Heather Tomlinson and I'm a professional support lawyer to the real estate practice group here at Evershed Sutherland. So our subject today then is Tenant Works and what you need to know about duty holder obligations, works in mixed use buildings and independent sections. I'm focusing on England today specifically because the law in Scotland is different, and whilst we've got some indications from the Welsh Government that Wales intends to introduce some similar provisions, they don't exist yet. So we're just looking at the position in England. And what I want to do is start off quite generally before turning our attention to some of the specific details around mixed use buildings. So there have been some fairly recent changes to the Building Regulations 2010. They've been fully enforced now for around about a year. There was a transitional period in place a little bit before that. And these changes introduced a new regime, which is commonly referred to as the duty holder regime. And those changes were brought about by some regulations which were made under the Building Safety Act 2022. But it's important to understand that these changes that were brought into the building regs don't just apply to residential premises. So although the Building Safety Act was this overarching piece of legislation arising out of the Grenfell tragedy and was aimed, a lot of its provisions were aimed at safety in residential buildings, these changes that were brought about to the building regs apply to anything which the building regulations themselves apply to. So that's any time that any building work as defined in the regulations is being carried out, these general duty holder obligations will apply. So the duty holder obligations are found in Part 2A of the building regulation. So a whole new part was put into the building regulations. And so you might sometimes hear them referred to as the Part 2A obligations as well. And they were brought into force by the Building Regulations, etc. Amendment England Regulations 2023, nice long name. And that was following the findings of the first stage inquiry arising out of the Grenfell tragedy. And the aim of these amending regulations, the aim of the duty holder regime, was to address a perceived culture of shifting responsibility in the construction industry. And the idea was that these changes would promote compliance with building regulations by clearly defining the roles and responsibilities of everybody who is involved in building work. Non-compliance with these obligations by any duty holders can result in criminal sanctions. And at the very extreme end, that includes imprisonment for up to 2 years and unlimited fines. So it's very important to understand and establish when those duty holder obligations apply, and then, of course, make sure that we comply with them. So let's just think a little bit then about the scope and when these regulations and the obligations apply, and therefore what is meant by building work. So the Building Regulations 2010 apply to all building work, and that's defined in the regulations as work arising out of erection or extension of a building, the provision or extension of a controlled service or fitting. So that can be things like air ventilation systems, things like that, but there's a whole list of them in the building regulations of controlled services and fittings. It relates to the material alteration of a building or material change of use. And then things like underpinning, insulation, requirements in relation to energy performance and things like that. So all of that would be building work to which the building regs and therefore the duty holder obligations apply. Certain types of building work are exempt from compliance with the building regulations. So if you're providing, for example, internal lighting in a small area where less than 100 meters squared of the floor area is being served by the lighting, or replacing toilet appliances, bathroom appliances, replacing guttering, things like that. So fairly small minor works are exempted from the building regs and therefore the duty holder obligations. The duty holder obligations apply when you're doing that building work to all buildings with some very limited exceptions. So the exceptions are for things like greenhouses, agricultural buildings, buildings used for keeping animals, buildings which aren't regularly frequented by people, temporary buildings as well, where they're erected but aren't intended to last more than 28 days, or ancillary buildings like site offices on a development site, for example. Some buildings are controlled by other legislation, and therefore they are not governed by the building regulations, but those are quite specific buildings. So things like the Civil Aviation Authority buildings, some buildings owned by statutory undertakers, nuclear energy buildings, those kind of things. But generally, the type of buildings that we're thinking about today for tenant works, fit outs, commercial units, retail units, that kind of thing, those exceptions aren't going to bite on those kind of buildings. So assuming that we're not then in an excluded type of building and we're not doing an excluded type of work, and so what we're doing is fit out or alteration works to a commercial unit or an office floor or something like that. So all of that falls within the building regulations. What does the duty holder regime do? And what does it mean for tenants who are carrying out those works in this type of building? Well, the first thing that the duty holder regime did was introduce this general competency requirement and duties for all duty holders. So that meant that any person who's carrying out building work or any design work must have the skills, knowledge, experience, and behaviours necessary to fulfil their duties and carry out the building work or design work in accordance with all relevant requirements. And where it's not an individual person, but it's an organisation who's providing who's doing the work, then they have to have the organisational capacity to do all of those things as well. So the general competency requirement also requires that duty holders all plan, manage and monitor the design work that's carried out and cooperate with other duty holders to ensure that the work is in compliance with all of the relevant requirements. So the duty holder obligations are then split down into separate obligations for clients, principal designers, principal contractors, and other designers and contractors who might be working on the project. I haven't got time today to go into detail on all of those, so I just want to pick out some key obligations for clients who, where we're talking about tenant fit out works, the client will almost always be the tenant company or tenant entity themselves. In some ways, these obligations are similar to obligations under the CDM regulations, so the Construction Design and Management regulations, which have been around for about 10 years. But you might have noticed that when I was explaining what the general competency requirement was, that I stressed the word behaviours when I said that any person carrying out building work or design work must have skills, knowledge, experience, and behaviours necessary to carry out the work. And that's new. That's something over and above what we find in the CDM regulations. So focusing then on the client's obligations as a duty holder, well, the client has to make suitable arrangements for planning, managing and monitoring the project, including making sure that there's a sufficient allocation of time and other resources to make sure that everybody involved can ensure compliance with relevant requirements. They also need to ensure that those arrangements are maintained and reviewed and altered and tweaked as necessary throughout the project. They need to provide information as soon as possible to every designer and contractor on the project and cooperate with everybody else who's working on the project to the extent necessary to make sure that person who has a duty or function under the regulations is able to fulfill that duty correctly. Where there's more than one contractor working on the project, the client must appoint in writing a designer with control over the design work as the principal designer for the purposes of the building regulations. And they also must make sure that there is a contractor with control over the building work who is the principal contractor for the purposes of the building regulations. Now, that's something that we're probably familiar with already from the CDM regulations, and it can be the same person or the same organisation performing the CDM principal designer and the building regulations principal designer roles, but it has to be there has to be an express appointment made in writing specifically in relation to the building regulations role as well. And those appointments have to be made before the construction phase begins. So where the appointment of a principal designer or a principal contractor ends before the end of the project, and the client must appoint a replacement. If the client fails to do so, if they fail to either appoint those people in the first place or appoint a replacement, then they have to fulfill those duties themselves until somebody else is appointed to that role. The client has to take all reasonable steps to satisfy itself that the parties they've appointed fulfill their general duties under the duty holder regime. And at the end of the works, the client has to provide the relevant authority with a signed statement within 5 days of completion of the work, confirming that to the best of the client's knowledge, the work complies with all applicable requirements of the building regulations. So what are the sort of the issues that presents, or the potential pitfalls or the risks, I suppose, for clients under this building regulations duty holder regime? Well, like any failure to comply with building regulations, any breach is potentially a criminal offence. Whilst it's not mandatory to keep a record of the steps that the client took to satisfy themselves that the principal designer and the principal contractor met the competency requirements and were able to fulfill their duties, it's prudent to do so. It's a good governance issue, and also it backs up that statement that's being made at the end that the works have been done in compliance with building regulations. Other risks then, so as I mentioned, if the client fails to appoint a principal contractor or a principal designer, then the client themselves must fulfill those roles. They must perform all of the duties that those people would otherwise perform. And if you're a commercial operator, you're a retailer, and you're just doing some works in your new unit, you potentially very likely that you won't have the requisite skills, knowledge, experience, and behaviours necessary in order to do so, and therefore you'll automatically be falling foul of the general competence requirements under the general duty holder regime. If at any time the client for the project changes, then the new client must also give notice to the relevant authority, confirming that they've done all of those things as well. So all of that applies to any works in any buildings that would require building regulations approval. But there are additional requirements where the works are being carried out to a higher risk building. And that's even where the part of the building that's being worked on is purely commercial. So perhaps it's like a mini or local or metro branch of a supermarket at the bottom of some flats, or it's a gym or a cafe or a bar at the bottom, or there's some office floors in a mixed use building where there are flats above. There's an enhanced version of those duty holder obligations I've just been talking about for works to premises in a higher risk building. And just a reminder that a higher risk building is a building in England, which is 7 stories or more in height or 18 metres or more, and which contains at least 2 residential units. So that applies to mixed use premises if that height requirement is met and we've got at least 2 residential units within it. So if works are being carried out to that higher risk building, in addition to all of those things that I've just mentioned about the duty holder obligations that the client has, they must also make suitable arrangements to make sure that information is provided to the designers and contractors working on the project and make them aware that the project includes higher risk building work. That work must also be kept periodically under review. And in this case, the principal designer and the principal contractor have to be appointed not just before the construction work starts, as we've just been talking about in the general duty holder regime, but those appointments must be made in writing before the application for building control approval is submitted. And we'll see in a moment how that application for building control approval is different in this regard as well. That stage for higher risk building work is generally referred to as Gateway 2, which I'll come back to in a second. So when the client appoints a principal designer and a principal contractor or anybody else under the enhanced duty holder regime, the client must keep a written record of the steps it took to satisfy itself that the party fulfilled the general competency requirement. So whereas before it was a good idea for good governance, it wasn't mandatory, here where you're doing works in one of those tall buildings, that is mandatory. And in addition to being satisfied that the general competency requirement has been met by the people who are being appointed, the client must also ask whether that person has had a serious sanction imposed upon them within the 5 years ending on the date of the appointment. And the client is also under a duty actively to consider any information relating to any other misconduct by that person. What is meant by a serious sanction? Well, that means a compliance notice or a stop notice has been issued against them in relation to some works that they've been involved with before, or there's been a conviction for an offence or a report into the death of somebody under the Health and Safety at Work Act or the Building Act. So quite an onerous set of things to do before you can make your appointment. And as I mentioned, you've got to make that appointment before you apply for building control approval. And I reference that that's commonly referred to as Gateway 2. The gateways and the whole of the gateway regime is something that we don't have time to consider in detail today. But the thing to be aware of, and the reason that it's important, is that where works are being done to a higher risk building, and we're talking here about commercial spaces within higher risk buildings, it's not a case of going to local building control for approval in the usual way. Because as well as introducing this new duty holder regime, the amendments that were brought about by the Building Safety Act included the establishment of a separate regulatory body, the Building Safety Regulator, which is part of the Health and Safety Executive, and it's their role to oversee works in higher risk buildings. And that's not just new builds, that's not just new blocks of flats, new towers that are being built. It's works to those towers, works to those higher risk buildings, unless a very limited set of exceptions applies for very minor works or emergency works in those buildings. So if you're in that enhanced regime, that gateway regime, why does it matter if you have to go to the regulator rather than normal building control? Well, it's because of the timescales that are involved. So even if everything was running smoothly, where you want to do works to a higher risk building or to a unit in a higher risk building, there'd be an 8-week period after making the application for approval for the building safety regulator to consider and respond to your application. And that 8 weeks is set out in a statutory in the statutory requirements. No works can commence until that approval has been granted. So that's 8 weeks straight up before you can do anything. If the works change during the programme, and they are fairly significant changes, back to the regulator you go, because you have to seek an updated approval. And again, you can't start those changed works until you get the green light from the regulator. There's also an 8-week period at the end of the works for the building safety regulator to consider and sign off. And at every single stage that you have to involve the regulator, there's a whole lot more documents required in terms of your change control management, things like that, to satisfy the regulator that the works that are being done in this tower, this tall building, are going to be safe. So if everything's running smoothly and everything's going well, you're looking at up to 16 weeks of regulatory delay on your works programme. But things are not running smoothly at all at the regulator at the moment. There are some quite significant delays being experienced by people going through the gateways regime. Some figures I saw recently were that there had been about 1,500 applications received for works to a higher risk building, so not building new ones, doing works within them. And of those, only around 250 had been approved. So 600 were still under review or had been subject to requests for more information from the regulator, and over 500 had been deemed invalid or had already been rejected. Delays in going through that process are being measured in months and months rather than weeks. Anecdotally, we've heard of somebody who's had an application in the system for around a year, waiting for approval to start their works. So it's clearly a massive issue, and for commercial tenants who are taking space in higher risk buildings, it presents a real concern in relation to getting your fit out works approved and underway, and potentially down the line when alterations are required, or if you already have commercial space in one of these buildings and you want to do alterations, it can be a massive issue there. The impact on work programs can be really significant. And as I mentioned, there are these additional regulatory requirements in terms of documents and procedures and things that the regulator expects to see. So it's a much more onerous process than going through the sort of normal building control approval. So does that mean that if you've got a unit in a high risk building that it's a complete disaster and it's all doom and gloom? Not necessarily, because there is a potential way for commercial occupiers in tall mixed-use buildings in those high-risk buildings. There's a potential way out of it. There's a potential avenue, alternative avenue, rather than having to go through this gateways regime and this enhanced regulatory regime. And that's because some more regulations that were made under the Building Safety Act make provision for this concept of an independent section within a higher risk building. Now, this exception can only apply once the building is no longer under construction. So it can potentially help for existing completed buildings where you've got a unit within a building that's already complete, but it won't assist for fit out works for a commercial unit that's undergone sectional completion while the rest of the higher risk building is still being constructed under the building safety regulator regime. So just considering this independent sections exception then, when the regulations which brought this concept into existence were published, the government also published an explanatory memo which explained what the thinking was behind this. So I'll just sort of read from that and tell you what that said and explain the purpose. So what the government said was that for the purpose of refurbishment work and the in-occupation part of this new higher risk building regime, it's possible for the building to be defined more narrowly in certain circumstances. And that's because it would be disproportionate to apply the duties and responsibility of the new regime across an entire structure in circumstances where the section that meets the necessary height and use requirements is independent and separate from the other parts of the wider building. So the regulations therefore allow for sections of a wider building to be defined as their own separate building if they meet a set of criteria. And sections that meet that criteria are known as independent sections. So that's what the government's explanatory memo said about independent sections and the reason behind having them. In short, the government was saying that really they were not overly concerned with these commercial units in higher risk buildings as long as they were sufficiently separate from the rest of the higher risk building. And really what their aim was in terms of those enhanced regulatory requirements was the residential parts of it. So the regulations set out specific requirements for when a higher risk building can be deemed to be, when part of a higher risk building can be deemed to be one of these independent sections. And understanding whether you fit into that exception requires quite a detailed look at the technical plans for the area, for the unit, together with an analysis of the legal tests that are set out in the regulations themselves. A lot hinges on the way in which the unit is accessed and the way in which people get in and out of that building and the degree to which there is overlap between the commercial and residential spaces. And the regulations have quite a specific defined way in which access needs to be interpreted. It's well worth investing the time and energy to consider the nature of the premises and whether they are an independent section at the earliest opportunity. So whether you're taking space in a new building, or whether you've got you potentially have got one of these units already and you're thinking about doing works to it. Because if the commercial unit can be said properly to meet that test and to be an independent section, then you'll be exempt from the more onerous gateway regime that I've just been talking about, and you'll be back in the normal building control approval world for the works that you want to carry out, which obviously will save a lot of time and cost for the works themselves. So I just want to sort of finish off and round up some of the key points that I've been talking about, some of the key takeaways. Firstly, all building regulations work, wherever you're doing it, whatever kind of building it is, must include compliance with the general duty holder regime. So if you're the client for works which are covered by building regulations, then make sure you know what you're supposed to be doing to comply with the duty holder regime and that everybody on the project has suitable competence. And make sure that you've made all the relevant appointments in time. Otherwise, you'll be on the hook to perform those roles as well, and you'll be held responsible for fulfilling those duties of those other duty holders. Secondly, think about across your portfolio where you have units that are within higher risk buildings. Where could you potentially have to comply with that enhanced regime, the gateways and so on, when you're next doing works to that unit? Thirdly, perhaps consider undertaking now a legal and technical review of those units to identify where you might be able to benefit from the independent section exemption to put yourself back in normal building control territory and outside of the onerous high risk building regime. It's potentially worth doing that even if you don't have works, imminently on the horizon, so that you've got an idea of where you've got that longer lead in time and where actually you think you might be in normal building control territory. And just one last thing to finish off. If you do the analysis and you think you've got an independent section and you go off to building control and ask for approval, they might not agree. And they might still send you off to the building safety regulator and say, no, this is works to a higher risk building. It's not an independent section. We don't agree with your analysis. If you end up in that situation, that's not necessarily the end of the story. So don't give up hope and think that you've got to go through that enhanced regime. There is a potential avenue to get that decision overturned, to get a declaration that in fact your property is an independent section for the purposes of the Building Safety Act. We've been through that process and been successful in getting those decisions made and getting works put back into normal building control. So if you do find yourself in that position, don't panic. There might still be something that you can do. And we're very happy to help with that if you do find yourself in that situation. Thank you so much for joining me today. Thank you everybody for listening, and I look forward to seeing you at the next Evershed Sutherland PROPcast.